You want to gain access to a safe deposit box after somebody has died. Hi, I'm Darren Findling of the Probate Pro. We're going to cover the process of using the State Court Administrative Order Form PC 551 to gain access to a safe deposit box that's held at a financial institution. Now, with all of these SCAO forms, State Court Administrative Order forms, on the bottom it identifies the form number. These forms are readily obtainable by doing Google searches or contact my office or through our website. We're happy to provide you one. Also, the form identifies the statute, as you can see from this floating arrow. And with all of these forms, the statute gives you guidance on how to use this form PC 551. Let's examine it. Well, there was a change in law as of October 1 of 1993. So if the death occurred before October 1 of 1993, which is a long time ago, this process is done differently because you have to make sure that certain estate taxes were resolved. But for everyone after September 30th of 1993, this form can be utilized to gain access to a safe deposit box. Now, I know a lot of people call it a safety deposit box, but it's actually a safe deposit box, and people often slur that together and just call it a safety deposit box. So how does this work? Well, if the safe deposit box is held at a financial institution and there is a joint owner, meaning there are two names on it, and you have the keys, you have every right to access the safe deposit box as the survivor. But if it is solely in the name of the individual who died, this is the process that you go through to gain access. The statute 700.2517 provides that you can gain access to the safe deposit box not to take the contents out, not to clear out all of the contents that exist within the box, but simply to search for either a will or a burial deed, a plot for purposes of burial. So often people get confused. This form is not able to be used to access the assets or even the contents within the safe deposit box. So completing this form and presenting it to a financial institution and then going in does not give you the right to remove the items from the box and bring it home. Those items have to remain there. This just simply gives you the opportunity to peer in to identify whether a will exists or a burial plot, burial deed exists, and then that item can be utilized and pulled out from the safe deposit box. Let's work our way through this particular form. At the top left, you would identify the county in which the individual was a resident when they died, and then the case number at the file number, you don't put anything there. The court will do that for you after you've completed the form and filed it with the probate court. At the top, you'll see you file the petition in the county where the safe deposit box is located. And I had referenced there earlier that you do it in the county in which the person was domiciled. And that actually is not correct. You do it in the county in which the safe deposit box exists, as long as the safe deposit box is in a county in which the probate court has jurisdiction over that individual. So that note is really important on that form to understand that, for example, if the person was a resident of Wayne County, but the burial deed, or the safe deposit box was in Oakland County, you'd actually file this in Oakland County, not in Wayne County. The next section is to identify the name of the estate. This is the name of the person that died. And I generally use the language right off the death certificate. Now, sometimes the safe deposit box may be under another name, for example, a married name or an alias. So if that does occur, you want to list the name identified on the safe deposit box and also known as the name that's referenced on the death certificate. The next thing is within the petition itself, you identify how you're interested in the decedent's estate and what role, what status are you making your request and petitioning the court. So for example, are you a spouse? Are you a child? Are you the nominated personal representative in a will, an heir, a devotee, etc.? Then you'd identify the date of death as well as the domicile of that individual. And the word domicile and residency are close. They're not exactly the same, but generally we use the information off the death certificate to identify the domicile unless it is incorrect for purposes of that determination. Again, to go into those finite details, contact me. I'll help you, guide you through it. Number 3 is the identification of the financial institution, whether it's a bank, a trust company, credit union, safe deposit company. You identify where you're trying to gain access to. So you can't just generically have this document and go from bank to bank, because often people are trying to find wills and they're not sure which bank. Is it at Chase, Comerica, Citizens Bank? Well, unfortunately, you have to identify for each of these the bank and financial institution you're going to utilize to present. To further complicate the matter, each bank where a safe deposit box exists has its own location, its own place, for example, rather than the whole banking system. So it's very frustrating for people as they're trying to navigate through this form that they may know that the person banked, for example, at Chase Bank, but they don't know necessarily which branch. And each safe deposit box is maintained at a local branch. Now, often the larger umbrella bank will tell you which branch there may have been accounts at, but often they won't. So this is quite frustrating if you have to go search from institution to institution. But nonetheless, you identify it, as well as if you are aware of the deposit bank number and the branch and location. And the reason this is relevant, of course, is if they had multiple branches and you're searching for one in Wayne County and another in Oakland County, you have to do 2 different forms for purposes of that search. Really frustrating. So this has some limitation in its application. Generally, we see this form used when people are pretty certain that the person maintained an account at a particular bank. We also know that in the last, let's call it 20 years or so, many people don't store their wills at a financial institution in a safe deposit box. There's less use of these boxes because so many of these kind of lock boxes are able to be purchased from big box stores and Walmart and so on, and people often keep those documents in their house in a lock box rather than utilizing a safe deposit box at a financial institution. And one of the prevailing reasons for this is that if it's kept in your home, you can gain access to it 24/7. If it's kept at a financial institution, you're subject to the banker hours. So that can be a limitation and a reason why so many people are not using financial institutions to store their original will. Also, an original will could be kept, for example, at the courthouse. So there's lots of different places if you're trying to figure out where to locate it. But nonetheless, this form is used when you're trying to gain access to a safe deposit box at a financial institution of which you presume or believe that the document will exist. As you move further down the document, you now make your request. What are you asking the court to do? Well, simply, you're asking for the person to be able to access and examine the contents of the safe deposit box in the presence of a banking person. Now, understand, this is quite different than when you have a letter of authority. When you have a letter of authority from a probate court, you get to view the safe deposit box outside of the presence of anyone. Outside the presence of a banker, outside the presence of any other family members. If you're given the legal authority within a letter of authority, you can gain access, and most importantly, you can remove the entire contents of the box. So this form is utilized when there isn't an estate, generally. This form is utilized when there aren't letters of authority, and there may not be a need to move forward with the full estate, or if you're trying to find a will to be able to then gain the authority within the estate administration to be able to move forward and not get a nomination as personal representative within a will that may be at a bank. So remember, this is allowing you to examine the contents of the safe deposit box in the presence of an officer or other authorized employee of the lessor. The lessor in this case is the bank or the financial institution for the purpose of removing and examining the will and deed or burial deed. The next section is a declaration under the penalties of perjury. So with every scale form, there's a declaration that the information contained within that document is true to the best of your information, knowledge, and belief. Below that, a place for the petitioner to sign, and if there's an attorney involved, an attorney's signature. Often people say to me, well, I'm the petitioner, but I don't have a lawyer. Can I still proceed to file this? And the answer is yes, of course. You can proceed. There's a space for the attorney to be identified, but it is not a requirement for purposes of completing and filing this particular petition. Further down, you'll see the court order. So remember, you're filing a petition, you're making an ask, a request of the court, and then if the court approves it, an order is entered. And as you can see on number 5, it is an order that the petition is granted, and that individual is permitted to access the safe deposit box for purposes of examination of the will or burial deed. Subsection 6 identifies during that time, there has to be a written statement certifying whether there is the existence of this will or burial deed, and that, pardon me, that document gets filed with the probate court or probate register, so that following the opening of the document, there's a certification whether the documents were identified in the safe deposit box or not. This really gives the court an understanding of, within that petition, whether that document existed or not, whether it was found or not. Signed by the judge, and then it's dated. So then this particular document, after it has been filed, you pay the requisite filing fee in the county in which the safe deposit box you believe is located. It's filed with the court, it gets signed by the judge. Then you take this document, generally with a death certificate, to a financial institution, present it. Now, keep perspective here. If you expect that you're going to be able to take this document straight over to a bank, walk in, and gain access to a safe deposit box, it's not going to work that way. Generally, they're going to send it to their legal department. Their legal department's going to examine it. And of course, if you don't have the key to a safe deposit box, remember the bank keeps a key, and the party that is utilizing or owns or is renting the safe deposit box has a key, and both of those keys get put in for purposes of opening and accessing it. Now, if you don't have a key, then they're going to require a drill out, and they charge an exorbitant fee to do that. They drill out the lock. And usually what happens is you present, it goes to legal, a few days go by, you schedule an appointment, you may need to hire a locksmith to do the drill out, and now if you do have the key, you go and access it, and then be able to utilize this form for purposes of gaining access to a safe deposit box. At the Probate Pro, we're passionate about probate-related issues. If you have questions about accessing a safe deposit box and using this petition or any probate-related matter, visit us at theprobatepro.com or call us at 833-PROBATE.